Hi everyone, Andrew Schultz, Principal Broker with Own Buffalo Inc. here, and today I wanted to come to you with some breaking news with regards to the eviction moratorium here in the state of New York. As of December 28th, 2020, Governor Cuomo has signed an extension to the eviction moratorium, extending that moratorium all the way out to May 1st, 2021. And I wanted to take this opportunity to provide you as a landlord, as a housing provider, as a property manager with some information about what this bill looks like. We're actually going to look at it page by page. I'm also going to take a look at the hardship declaration that a tenant would be providing to a housing provider in the event that they are experiencing a hardship. And last but not least, we're going to talk about some options that landlords, housing providers, and property managers have in navigating these muddy waters. Before we jump into all that, I do want to remind you that I am not an attorney. I am a property manager, I'm a real estate broker, but I am not an attorney. You should definitely consult legal counsel, competent legal counsel, before moving forward with any sort of an eviction action with regards to your tenants, especially nowadays with as many changes as there have been to the laws, even as recently as a couple of days ago. So we're going to go ahead and jump right in here. This is just a press release off of Governor Cuomo's website. Governor Cuomo signs the COVID-19 Emergency Eviction and Foreclosure Prevention Act of 2020. A couple of things that I highlighted on here. Prevents residential evictions, foreclosure proceedings, credit discrimination, and negative credit reporting related to the COVID-19 pandemic. Scrolling down a little bit further, it just touches a little bit on the residential evictions portion of things. Moving now over to the New York State Senate's website, you can see that this is Senate Bill S9114. That is the bill that is referenced in the press article here. We are looking at the correct bill. And you can see down here that this has passed the Senate, passed the Assembly, and been signed by the governor as of December 28th, 2020. This is the law of the land as it sits right now. Let's go ahead. We're going to switch over to the actual bill. This is just a PDF copy of the bill that I pulled down so that I could highlight it. We're going to go through, I'm not going to say necessarily section by section, but there is going to be, there we go. Not necessarily section by section, but I will break things out and make some notes here as we go through. I highlighted this big section in orange right at the top. This is essentially a lot of the same language that the federal government used in their CDC moratorium. It's interesting that they chose to use basically the exact same language. You know, do with that what you will. Let's jump into Part A here. We're only going to be looking at Part A of this legislation. Part B deals with the foreclosures on hold, the credit discrimination, tax foreclosure sales, and tax exemption protections. We're not getting into any of that stuff today. If you're interested in seeing a video on that, comment down below and we'll do a video on that for you as well. So Part A, we're talking about the definitions of an eviction. I'm not going to sit and read all of this text word for word, but essentially what this boils down to is right here. This only covers residential dwelling units. This does not have any impact on the commercial side of things. This is only dealing with residential dwelling units. I'm going to scroll down a little bit here to Section 4. And again, this is Section 1, subsection 4. This talks about the actual hardship declaration. We're going to get into much more detail on that after we're done with the bill itself. But one thing I did want to point out here is that they specify that it has to be provided in 14-point type. It also has to be provided in the tenant's native language whenever possible. And there is a responsibility on the landlord to ensure that the tenant is receiving this information in their native language. So we're going to scroll down here. All of this orange you'll see in a little bit. This is actually the hardship declaration. I pulled this out and moved it into a separate Word document just to make it a little bit easier to read, but we'll dissect that in a minute. Section 2. So this is actual Section 2. Talking about pending eviction proceedings. Any eviction proceeding pending on the effective date of this act, which is December 28th, 2020, including eviction proceedings filed on or before March 7th, 2020, or commenced within 30 days of the effective date of this act, shall be stayed for at least 60 days. What does that mean? There's a 60-day stay on all evictions effective as of December 28th. And actually the non-highlighted section there goes on to talk about the fact that the chief administrative judge here in the state of New York can extend that if they so choose. Let's see here. Section 3 talks about pre-eviction notices. Essentially what this boils down to is that you have to send a copy of that hardship declaration with every late rent notice, with every demand for payment, any lease violation, any petition, et cetera, et cetera. You have to include a copy of that hardship declaration along with whatever the notice is that you're sending. The notice must include a resource list available to tenants where they can go and try to get rental assistance. And while that sounds like it might be a little bit of a headache, it's actually good news for the landlord. It shows that you're trying to help the tenant, and we'll talk more about that in a little bit. But you do have that obligation to provide not only just the hardship declaration, but also a list of resources that the tenant can try to pursue to get their rent brought current or whatever the case may be. There's a little bit more information here. So this section, part 2, that talks about the nonprofit legal service providers actively handling housing court matters. You have to provide on your notice, obviously the tenant has to know how to reach you. That makes sense. And section 4 here is the prohibition on the initiation of eviction proceedings. If there's no pending eviction on a tenant and that tenant provides you with that hardship declaration, you cannot initiate an eviction proceeding until at least May 1st, 2021. Jumping down here a little bit, we're now in section 5, subsection B. What this talks about is attesting that the respondent or another tenant or occupant of the dwelling unit that is subject of the proceeding has returned their hardship declaration, but that the respondent is persistently and unreasonably engaging in behavior that substantially infringes on other tenants' rights to use. Let me see if I can change the color of this to green, maybe. There we go. Nope, not quite. Good enough. So essentially, this section is talking about that lease violations are still evictable. And this is really important because this is basically going to be if you're looking for an eviction, if your tenant is in violation of the terms of the lease outside of non-payment, for instance, they're dealing drugs in the property, or they have 17 people living in a 2-bedroom apartment, something along those lines, those are still considered lease violations and those are still evictable. So you do have that option available if you have a tenant that's just being non-compliant on their lease. They have no interest in paying, excuse me, they have no interest in paying their rent, but that's not the real reason that you have that you want them out. You really want them out because of the other issues that they're causing. You know, you still have that as an option, which is good news. So we're going to scroll down here a little bit, jumping to section 6. And section 6 basically states that once a hardship declaration is received, that eviction is going to go into a stay status until May 1st, 2021. Moving forward into section 8, there's a lot of text here. I'm going to actually, I'm not going to sit and read through the entire thing, but I will give you just a brief synopsis of it. Section 8, part A1, basically is telling us that the eviction warrant, if an eviction warrant has been issued, but that eviction warrant has not been executed, you will have to go through a status conference with the tenant and the court prior to being able to execute that warrant. And by the way, section 2 says that that tenant is staying there until May 1st regardless. They're probably not going to be executing that warrant if the tenant provides them with the hardship declaration. They're not going to be executing that warrant until at least May 1st, 2021. So that's section 1. That's this top section from lines 12 to 24. Subsection B, which runs from 25 through 38, warrants that have been issued must state that the tenant has not supplied a hardship declaration or that the tenant is ineligible for the hardship declaration due to their lease violations. So if you have a warrant that's already been issued, chances are your warrant will need to have this information added to it, that the tenant has either not submitted their hardship declaration or that the tenant is not considered eligible for a hardship declaration because it's a lease violation issue. It's not, a hardship issue. Scrolling down a little bit, this is section 8, subsection E. This is something that I'm going to have to get a little bit more clarification on, but the way I'm looking at this is that the tenant can execute their hardship declaration right up until the point of set out. I'm actually going to read through this. Unless the warrant contains the information contained in paragraph 2 of subdivision B of this section, which we just talked about. Sorry, I'm opening my bottle of water here. If any tenant delivers a hardship declaration to the officer to whom the warrant is directed, the officer shall not execute the warrant and shall return the hardship form to the court, indicating the appropriate index case number the form is associated with. So This is talking about the setouts. Basically, section C, D, and E are talking about setouts here. And my understanding of this is based on what I'm looking at. I believe that the tenant has the option of executing that hardship declaration right up until the point of setout, unless they are in violation, like the lease violations, which we were talking about previously, which is what section 9 talks about. Section 9 states that sections 2, 4, 6, and paragraph 2 of subdivision A of section 8 of this act shall not apply if the tenant is persistently and unreasonably engaging in behavior that substantially infringes on the use and enjoyment of other tenants or occupants or causes a substantial safety hazard to others, provided that ... We'll move on to that in a second. But I wanted to mention what exactly is that nullifying. Section 2 is the 60-day stay on all evictions. Section 4 is the no new evictions until May 1st, 2021. Section 6 is the hardship declaration. Once the hardship declaration is received, it stays the eviction until May 1st, 2021. Section 8A2, again, is the hardship declaration staying the eviction until May 1st. So essentially what that first section of Part D is doing is, in the event that you were going for the lease violation, all of that stuff about the hardship declaration becomes irrelevant. So going further into Section 9 here, there are several criteria that you would have for lease violations and how you would proceed with a lease violation case. Point 1, if an eviction proceeding is pending on the effective date of this act, but the petitioner is not previously alleged that the tenant has these lease violations, essentially you will have to, the petitioner shall be required to submit a new petition with the allegations and comply with all notice and service requirements under Article 7 of the Real Property Actions and Proceedings Law and this Act. Essentially, if you have an open eviction case with this tenant already for a non-payment matter, and now you're trying to say, okay, it's elevated to the point where this tenant now has 17 people living in a 2-bedroom apartment, you have to start a new petition. You can't just tack this on to your previous petition. If the court has awarded a judgment against a respondent prior to the effective date of this act, which is December 28th, 2020, on the basis of objectionable or nuisance behavior, the court shall hold a hearing to determine whether the tenant is continuing to persist in engaging in the behavior, et cetera, et cetera. Essentially, if this is an old allegation and a judgment has already been awarded, you're going to get pushed to a status conference to make sure that everything is still happening that you state is happening prior to that tenant being set out. Subsection 3, for the purposes of this act, a mere allegation of the behavior by the petitioner or an agent of the petitioner alleging such behavior shall not be sufficient evidence to establish that the tenant is engaged in such behavior. All that says is you have to be able to prove that they're doing what you say they're doing. Subsection 4, if the petitioner fails to establish that the tenant persistently and unreasonably engages in that behavior, or the tenant has provided a hardship declaration to the petitioner, the petitioner's agent, or the court shall stay the eviction until shall stay or continue to stay any further proceedings until May 1. So if you are unable to prove that the tenant is causing these issues, and the tenant has provided you with a hardship declaration, that is a stay of the eviction until May 1st, 2021. And subsection 5, if the petitioner establishes the tenant persistently and unreasonably engages in such behavior, or the tenant fails to provide a hardship declaration to the petitioner, agent, or the court, the proceeding may continue pursuant to Article 7 of the Real Property Actions and Proceedings Law. So if you can prove it, or there's no hardship declaration, it sounds as though you can proceed here. And then this section, I highlighted this in orange because it's not necessarily something that needs to be covered in great depth, but I did want to mention it. Translation of the hardship declaration. You have to provide the hardship declaration to the tenant in their native tongue. For most of us, that's going to be English. You may have Spanish-speaking tenants. You may have, here in Buffalo, we have a lot of Burmese-speaking tenants, things of that nature. The landlord has the obligation to provide the declaration to the tenant in their native language. The state is offering several different language translations of the hardship declaration that you can take a look at, download, use for your purposes. You can find those on the state court's website. This part 11, section 11, this is actually going to be pretty critical. Rebuttable presumption. A hardship declaration in which the tenant has selected the option indicating financial hardship shall create a rebuttable presumption that the tenant is experiencing a financial hardship. And there's some additional text here, but essentially what this boils down to is the hardship declaration is going to be considered as fact by the court. You as the housing provider have the obligation to defend against that claim. Make sure that you come in prepared for that defense. Make sure that your competent legal counsel comes in prepared for that defense. Moving forward a little bit, Section 13, this act shall take effect immediately, and this is as of December 28th. And sections 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, and 12 of this act shall expire on May 1st, 2021. So that basically states that from December 28th, 2020 to May 1, 2021, this is the law of the land. So now let's move on and take a look at this actual, this is the hardship declaration. So what I'm going to do, let me grab that PDF and scroll back up. That big orange block of text here, this giant hardship declaration here that I highlighted in orange, I pulled that out, I moved it over to a Word document to clean it up a little bit. I even changed the font size to 14. Not sure if you guys can see that on screen or not, but hey, it's compliant. Notice to tenant, if you've lost income or had increasing costs during COVID-19 or moving would pose a significant health risk, you cannot be evicted until May 1, 2021 for non-payment of rent or for holding over after the expiration of your lease. I don't think that I'd actually touched on that so far in this video. This applies to non-payment and to holdover. So we no longer have the option of, all right, your lease is up, it's the end of your lease term, we're just not going to renew it. That, the holdover option's not available to us here. So this is for non-payment or for holdovers. If your landlord's provided you with this form, your landlord must also provide you with the mailing address and email address to where you can return the form. We already talked about that. If your landlord has already started an eviction proceeding against you, you can return this form either to your landlord, the court, or both at any time. You should keep a copy or picture of the signed form for your records. You will still owe any unpaid rent to your landlord. You should also keep careful track of what you have paid and any amount that you still owe. That's pretty important. I'm hoping that there are some tenants that are watching through the video and have made it this far and are seeing the fact that you will still owe any unpaid rent to your landlord and that you should keep track of what you're paying and what you're not paying. And then obviously it gives you some information or gives the tenant some information about resources that may be available. I don't think that this meets the requirement of the act in terms of providing a list of possible resources. I don't know that for certain. Again, I'm not an attorney. But I would assume, based on the way that I've read things, you would have to provide that list of resources. So now we're getting into the actual declaration of hardship. And you can read through this at your leisure if you so choose. But you must indicate below your qualification for the eviction protection by selecting A or B or both. So A basically relates to financial hardship. I'm unable to pay my rent or other financial obligations under the lease in full, or obtain alternate suitable permanent housing because of one or more of the following. Part 1, significant loss of household income. That makes sense. Part 2, increase in necessary out-of-pocket expenses related to performing essential work or related to health impacts during the COVID-19 pandemic. Part 3, child care responsibilities or responsibilities to care for an elderly, disabled, or sick family member during the COVID-19 pandemic have negatively impacted my ability to pay, negatively impacted my ability or the ability of someone in my household to obtain meaningful employment or earn income, or increase my necessary out-of-pocket expenses. Part 4, moving expenses and difficulty I have securing alternate housing make it a hardship for me to relocate during the COVID-19 pandemic. Part 5, other circumstances related to the COVID-19 pandemic have negatively impacted my ability to obtain meaningful employment, et cetera, et cetera, et cetera. So essentially, if they're having a financial hardship, some sort of a financial hardship, they're going to choose option A here. Part B, vacating the premises and moving into a new permanent housing would pose a significant health risk because I or one or more members of my household have an increased risk of severe illness or death from COVID-19 due to being over the age of 65, having a disability, having an underlying medical condition, which may or may not include, but is not limited to, being immunocompromised. So that would be part B. You essentially are going either, all right, I've got a financial issue or I have a health issue. Those are the two options that tenants are being provided with here. These highlighted sections are, in my opinion, the most important sections of the entire hardship declaration. I understand that I must comply with all other lawful terms under my tenancy, lease agreement, or similar contract. I further understand that lawful fees, penalties, or interest for not having paid rent in full or met other financial obligations as required by my tenancy, lease agreement, or similar contract may still be charged or collected and may result in a monetary judgment against me. I further understand that my landlord may be able to seek eviction after May 1, 2021, and that the law may provide certain protections at that time that are separate from those available through this declaration. Signed, print, date. Notice, you are signing and submitting this form under penalty of law. That means it is against the law to make a statement on this form that you know is false. So essentially, they don't want tenants perjuring themselves. They don't want tenants lying on these forms. So your tenant's going to fill out this hardship declaration. They're going to give it back to you, or they're going to give it back to the court to attempt to stop their eviction until the beginning of May 2021. What are the options that are available to the landlord here? Let me change screens here real quick. So what are the options that are available to you as the landlord in a situation such as this? You do have a few options available. My first line of advice to you will be hire competent legal counsel now. And when I say competent legal counsel, you're not looking for any attorney. You're not looking for the personal injury attorney. You're not even looking for the attorney that does real estate closings necessarily. You want a landlord-tenant attorney that is well-versed in what's going on with regards to this pandemic, with regards to this eviction moratorium, and understands the ins and outs of this legislation. You don't want just a general practitioner attorney, the guy that's doing your wills and estates and stuff like that. He's probably not going to have this knowledge base. You need to understand what attorneys in your area are up on this information and are able to provide you with competent legal counsel in these matters. Do not white knuckle this. Do not try to do this on your own. You will screw something up. We're at the point now where it's come so convoluted that legal counsel is going to become almost a necessity in these sets of circumstances. Hire competent legal counsel now. Number two, try to help your tenants. You're legally required to anyway. You have to provide them with that list of available resources that they can try to pursue to help them get caught up on rent or whatever the case may be. You're going to have to do that anyway. This is an excellent opportunity for you to help your tenants out, try to nudge them in the direction of getting some assistance. You may be in a situation where you can actually help them to file that paperwork on their behalf. I believe the federal eviction moratorium includes some information on that. I haven't dug into that yet. Don't quote me on that. But you may be in a situation where you as the housing provider can fill out the paperwork and the tenant just has to sign it or whatever to try to get some sort of assistance coming through the door for the tenant, try to get some rent funds coming through the door for that tenant. So when you're doing that, it's a good idea to update your information about the tenant, who's living in the apartment, everybody's names, everybody's date of birth, phone numbers, email addresses, copies of ID if you have it. Are you working? Where are you working? Et cetera, et cetera. If you're helping tenants with paperwork, you're probably going to wind up updating a lot of your information on those tenants as you're doing this process. And that's going to benefit you a couple points down here. Point number 3, get your notices filed. Have your legal counsel do this and do not wait. There's going to be a wave of evictions at some point. It's a self-fulfilling prophecy. At this point, we have now pushed and pushed and pushed and pushed evictions to the point where we're going to be a year plus before evictions are really going to start moving forward again. They've created a self-fulfilling prophecy. There's going to be a wave of evictions. The best thing that you can do is try to get out in front of that wave as much as possible. Get your notices filed, your late rent notices or whatever the case may be. Start your notice periods now because that's going to shorten your timeline come May 1st, assuming we can start filing evictions at that point. Number 4, pursue a money judgment. You do have the option of pursuing a money judgment. As a matter of fact, it's mentioned. Let me pull that back up on my screen here. We're now going to be back on the hardship declaration. It even states right in here that you do have the obligation, you do have the right I further understand, seek eviction after May 1, 2021. There we go. May result in a monetary judgment against me. So monetary judgments are still a viable option here. If that's something that you want to pursue, and I would seriously recommend it, I would say talk to your competent legal counsel about getting a money judgment. The nice thing about a money judgment is it's completely allowed, number one. Number two, they're already in your property, so it's very easy for you to serve the money judgment notice against them and get them into court to get that money judgment. If you did step two, then you're going to be in a much better place to take care of this step, because you're going to have so much more knowledge about who's living in the property, what their means are, what their means aren't, whatever the case may be. Keep in mind that a judgment will follow for 10 years, that tenant, anywhere they go. So that judgment is going to follow them when they go to try to buy a home, when they go to try to buy a car, whatever the case may be. A judgment's not necessarily going to be an instant payoff. You may never see a payoff on it. But down the road, it might be 2 years, it might be 5 years, whatever. You may find that that tenant comes back to you and says, hey, I need to clear this judgment so that I can move forward with something. What's it going to take to get this judgment cleared? At that point, you might be able to make some kind of a negotiation with them, whatever the case may be. You know, that's a down the road thing for you to worry about. But keep in mind that a judgment will follow for 10 years, and you have the option of renewing it for another 10 years on top of that. Last but not least, understand judicial discretion. Some courts are not hearing anything at the moment. I believe City of Buffalo is one of those courts that's not hearing anything at the moment. Different courts are handling this a little bit differently, just in terms of scheduling and what they're hearing, what they're not hearing, things like that. Just because cases are not being heard right now, that does not mean that you can't start your filing. Essentially, what's going to happen is you'll mail your filing in. You're not going to get a court date. You're just going to get your paperwork back with a TBD date, and they will let you know what your court date is once they can actually start scheduling cases and going forward. So understand that judicial discretion is a thing, and you do have a long road ahead of you. And that pretty much wraps up everything that I wanted to talk about when it comes to this piece of legislation. So as I had talked about earlier on here, you do have a couple of options as a landlord, as a housing provider, as a property manager. You do have a couple of options here, especially if you have a tenant that's really a huge nuisance to the property, a drug dealer, an overcrowding situation, something along those lines. There are still a couple of options here for some of the fringe cases, but the eviction moratorium largely has been extended to May 1st, 2021. I want to take an opportunity to remind you again that I am not an attorney and that you should definitely consult legal counsel before you try to do anything with regards to one of these evictions or serving notices at this point or anything else like that. In the future, we're going to have an upcoming video with regards to PPP for round 2 to see what we have available to us as housing providers in round 2 of the PPP, the Payroll Protection Plan funds. If you're interested in seeing a video on foreclosure protections or tax foreclosure, let us know and we'll do a video on that. Last but not least, if you're looking for competent attorney referrals, give us a shout. Call us here in the office, 716-608-3200. We'll be glad to refer you to a competent attorney that can help you through this situation. And last but not least, obviously, if you're looking for competent property management, feel free to give us a call at 716-608-3200. We'd be glad to talk to you about your current property management situation and see what we can do to help you with any situation that you may be experiencing. New episodes of Ask a Property Manager drop every Wednesday at 10 a.m. Eastern. You can also hear us on Facebook. We upload the replay every day that we do an Ask a Property Manager. We upload the replay that same day onto our YouTube channel. You can also catch us on the Rent Prep for Landlords podcast. New episodes of that drop every Thursday morning, anywhere podcasts can be heard, or over at rentprep.com/podcast. Thank you all so much for taking the time to watch this video. I truly do appreciate it. Again, I'm Andrew Schultz, principal broker of Own Buffalo Inc. Thank you for watching, and we'll talk to you again super soon.